Good afternoon, everybody. This is Carlos Rodriguez with Regis. I want to once again thank everybody for joining this call. I know we're all going through some very tough times and trying times. This has affected all of us in one way or another. I can assure you that Regis and the entire team at Regis is focused on helping our clients, on helping our clients' employees, on trying to figure this thing out. So just bear with us as we all go through this, we got to believe that there's hope at the end, or light at the end of the tunnel, as they say. And together, I'm confident we'll make it through this. I want to introduce Carlos and Kelly, Carlos Zumpano and Kelly Cueto from Zumpano Castro, who have been our attorneys from day one, and I want to thank them sincerely for working so hard and making sure, trying to understand everything that's passing as quickly as it's passing, and making sure that, passing that information on to us. So without further ado, because I know we all got things to do, Carlos and Kelly, are you there?
Yes, we are. Thank you, Carlos.
Thank you.
Thank you, guys. And throughout the presentation, there's a place where you can ask questions. Feel free to go ahead and ask questions. We'll try to answer as many as we can. And if not, we'll definitely answer them later on. I know the webinar we did a couple of days ago, those answers that were asked should be sent out soon. So thank you for your patience as we get that out to everybody, as well as the presentation from last time. So Carlos, Kelly, thank you.
Thank you all very much, and thank you, Carlos Rodriguez, and the entire Regis team. And I have to just tell you, as counsel, I'm impressed and grateful to see people like you, Carlos, and Regis reaching out to their client base and helping them understand what's going on in a very extraordinary time. A time that I don't think anybody imagined would happen so quickly and cause so much damage and hurt around the world. So I commend Regis and thank you for the opportunity to speak today. Like Carlos said, we will be circulating. We already have in draft form the answers to the first webinar we did. And if there's anything else we want to put in writing, we'll combine them with that draft and circulate that to Carlos. So we're going to start today with the supplement, basically taking off where we ended in the first webinar, but it will allow you to see comprehensively what the Senate and what the president has signed into law just recently. So we're going to start with the Families First Coronavirus Response Act and some of the major parts to it, and what are important facets that apply across the board to businesses and important for you to understand. We're going to go through 4 quick parts, and we're going to end with a lengthier question and answer session. We hope to get through quickly what changes the Senate and the president have done to the original House bill that we spoke about earlier this week. And then we're going to get into a more lengthier question and answer session, as I know a lot of you have a variety of questions that you'd like to discuss and throw out there, into the forum. So we'll start with part 1. And what does this Senate president change do to the expanded FMLA the House originally proposed? What does it do to the emergency paid sick leave, tax credits, and the Emergency Unemployment Insurance Stabilization and Access Act of 2020, which expands unemployment insurance and so forth? Part 1, we're going to start with the expanded FMLA. Okay. All right. Before getting to expanded FMLA, when does the expanded FMLA and paid sick leave take effect? So here's a quick timeline of what's going on big picture. March 18th, it was signed into law by the president. This is the House Act that was amended by the Senate and signed in by the president. April 2nd is the date that it's expected to become effective, and it's scheduled to sunset on December 31st, 2020. And we believe that December 31st date is a moving date because depending on how much of a toll the virus takes on the world in the United States, it may be sooner, maybe later, we just don't know. All right. Expanded FMLA. There's been some significant changes since we last spoke. The scope of it and who it applies to has been significantly reduced. Now, if you recall correctly, expanded FMLA really is there as FMLA in general there's an unpaid leave option for employees who qualify for FMLA, and it preserves their position for about 12 weeks. What the government is doing now in this expanded FMLA, both in the House and Senate bill, is that which the Senate approved bill, if you become part and qualify for the expanded FMLA, you're actually going to be getting a large portion of it for 3 months. So it's the first 10 days will be unpaid and the remainder of it will be paid. Covered employers stay the same. It's public employers and private sectors with fewer than 500 employees. Same thing, you have to have been on the payroll for 30 calendar days. So if you were just hired, you're not part of the expanded FMLA. This expanded FMLA does two main things. It preserves the position, which we all know about. Although in this new act, expanded FMLA, there is a nuance to that, which we'll get to down below for employers with 25 or less. But the purpose of FMLA is to preserve the position, and now the purpose for the first time is to expand a portion of that 12-week period as paid. But now it's been severely limited by the Senate and the President. There is only one circumstance that expanded FMLA applies, and it has nothing to do with being diagnosed, infected, or getting tested for, or anything related to the actual coronavirus infecting an employee. It is limited to school closures, circumstances where an employee is unable to work or telework due to a need to care for a minor child, if the child's school or child care provider has been closed or unavailable due to a public health emergency. Now, we all know that there are millions and millions of children whose schools have been closed, so that's a big part of the workforce. But that is the only reason that the expanded FMLA applies now. If you recall, in the first webinar, we talked about the other reasons that involve the coronavirus itself. That you can eliminate now for purposes of this discussion. So this one is very limited to employees whose children have had their schools closed due to a public emergency. As discussed, first 10 days unpaid, but the employee can take accrued PTO or sick leave, but the employer cannot require the employee to take the accrued paid leave. It is a right. Remaining 10 weeks is paid. Now, a lot of questions have come out and said, well, wait a minute, if I pay him at the full rate, that's overly burdensome. Well, what the Senate and President have done in the final bill is it's capped the amount that's being paid to the employees. If they qualify beyond the 10th day, you start paying at 2/3 the employee's regular rate of pay for the number of hours the employee would otherwise be scheduled to work. However, per employee, it's capped at $200 per day, and during the entire 12-week period minus the first unpaid 10 days, except if they have accrued PTO, it's $10,000. So the maximum you'll pay per employee by the end of the 12-week period is $10,000.
For the FMLA.
For the FMLA, right. We're going to get into paid sick leave now, which is different. This is just the expanded FMLA and only applies to those employees with who's had their kids' schools closed and are working and are at home and not working for the company. Job protection. At the end of the 12-week period, you must restore the position to the prior position or equivalent. However, there's an exception here. There's an exception in the final bill for employers with fewer than 25 employees if the position no longer exists due to operational changes caused by public health emergency. That is a huge deal because of what's going on from a public health standpoint. So what the Senate and the President did was tell the public, look, we know FMLA is to protect the position. However, we're at extraordinary times. There's an exception for employers with fewer than 25 employees. There's another exclusion. It does not apply to healthcare providers nor emergency responders. In addition, exemptions. Small businesses may be exempt, and small businesses are fewer than 50 if providing required leave would jeopardize the viability of the business. Now, a lot of questions have surfaced. How do you determine if you qualify for that? There's no current guidance. It's not an express exemption, and there's not an automatic exclusion. However, we do expect there to be more guidance in the coming days. I think that's what they did now is quickly pass it. They wanted to follow up on the House, and even though they don't have a lot of details, which is the biggest complaint of the Senate, they got some major changes across the finish line, but there's more to come. And this is one area where we'll probably see more details as to who may be exempt and who may not be. We're going to go into paid sick leave now.
All right, paid sick leave. This has not changed all that much since what we covered for you all earlier in the week. So covered employers are those covered public employers and the private employers with fewer than 500 employees. And again, it's immediate eligibility. So there's no 30-day payroll requirement like the expanded FMLA. Again, exclusions, this was the Secretary of Labor Authority provided that healthcare providers and emergency first responders may be excluded from coverage by the employer In other words, the employer may opt out of providing this paid sick leave for those types of workers. Exemptions, again, Secretary of Labor has the authority here to provide the exemptions for businesses with less than 50 employees. Again, same circumstances here with what Carlos had mentioned earlier. If the viability of the business is a going concern, and the reason that the exemptions and exclusions are set up this way is to ensure that there's consistency between the expanded FMLA and the emergency paid sick leave standards and the way the tax credits are set up for both. Okay, so what are the qualifying reasons? The qualifying reasons are that the employee is unable to work or telework because the employee is subject to federal, state, or local quarantine or isolation or order related to COVID-19. The employee has been advised by a healthcare provider or self-quarantine because of COVID-19. The employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. The employee is caring for an individual subject or advised to quarantine or self-isolate. It looks like the formatting got a little bit messed up here, but we're going on to numbers 5 and 6. The employee is caring for, this is number 5 here, the employee is caring for a son or daughter whose school or place of care is closed or the child care provider is unavailable due to COVID-19 precautions, or number 6, the employee is experiencing substantially similar conditions as specified by the Secretary of Health and Human Services in consultation with the Secretary of Labor or Treasury. So for emergency paid sick leave, how long? Again, this is similar or the same as what we had told you before. It's 80 hours of paid sick time for full-time employees. The number of hours the employee is typically scheduled to work for less than full-time. So that's that pro rata that we had told you about before. And how much do you need to pay them? It's their regular rate of pay if it's for their own illness, which was those reasons 1 through 3 that we just went through. Again, there's a cap. So this one is capped at $511 per day or $5,110 for those 80 hours. And it's 2/3 of the employee's regular rate of pay if it's for the employee's care of others, which was reasons 4 through 6. And that is also capped at $200 per day or $2,000 for the 80 hours. Other notes on the emergency paid sick leave. So this is in addition to any paid sick leave that an employee may already have. It's also not going to carry over beyond December 31st, 2020, unless there's, of course, additional legislation passed. And it works in conjunction with the expanded FMLA. So the employer is required to provide the employee with this paid sick leave instead of the unpaid 10 days of expanded FMLA if the employee is eligible for both. In other words, if the employee qualifies for both the paid sick leave and the expanded FMLA, the employee can have the 80 hours paid instead of the unpaid first 10 days of the expanded FMLA. In terms of calculating the rate of pay for emergency paid sick leave, it's based on the average number of hours that's worked by the employee during the previous 6 months. For employees who have worked less than 6 months, they're entitled to leave in the amount of the hours that they would normally be scheduled to work over a 2-week period. We have been receiving a lot of questions about tipped employees. There's no specific guidance yet. Best practice, of course, you want to make sure that they're receiving at least the amount based on the minimum wage, but we are telling all of our employees to calculate based on an average using a 6-month look back, just like the guidance above for the look back period. So for tax credits, this is similar to what we had spoken about earlier in the week as well. It's a 100% tax credit. So with respect to how they're going to be administered, it's via the Social Security Administration. The credits are against the employer portion of Social Security taxes. For both the Emergency Family and Medical Leave Expansion Act and the Emergency Paid Sick Leave Act, it's 100% for each. The offset is as I mentioned, capped at $200 per day and $10,000 total per individual under the expanded FMLA, and capped at $511 per day, $200 per day if caring for others, that's that 2/3, for up to 10 days for the emergency paid sick leave. This is the big one. These tax credits are only for employers who are required to provide the expanded FMLA and emergency paid sick leave. So if you are an employer of more than 500 employees and you are not required to provide paid sick leave pursuant to this law, you are not going to be eligible for these tax credits. Part 3 is the Emergency Unemployment Insurance Stabilization and Access Act of 2020. If you'll recall, we kind of said more to come. The federal government was encouraging the states to act quickly on loosening the requirements of who is entitled to receive unemployment. And so here's what they did in the new bill that the Senate revised from the House and the President signed. And what they did was they provided $1 billion in emergency grants to the state unemployment insurance funds, but only if the states meet certain criteria. So what does it mean for you as an employer? Well, what it means for you is that one of the criteria that the states are now going to meet is that employers are going to need to provide notification to the employees at the time of separation of any employment that unemployment compensation is available to the employee. So depending on what your process looks like in terms of termination, you need to make sure that you're doing that when Florida acts to get itself in line with getting ready to get this grant money. So employers should continue to monitor the changes to state unemployment compensation. We've seen some states already pass emergency measures. We've actually seen some states, as I mentioned on the phone call on Wednesday, I mentioned Washington and Georgia. I just saw something additional come out with respect to Georgia that's actually penalizing employers that are not assisting their employees in obtaining unemployment benefits. So, be very, very, very cautious in terms of what's happening in the unemployment space. Make sure that that you know what you need to do as an employer to help make sure that your employees or former employees are eligible for receiving benefits. And
this is a great time to be with a PEO like Regis, because obviously you have the master unemployment or insurance relationship with them, and you can also call them as a resource.
Okay, so we blew through that very quickly so we could open it up to Q&A, which instead of having questions and answers preset, which we had done on the previous one, we wanted to be able to answer them live via the chat function. I know we've started to receive a whole bunch of them already, so we will see what we've got. So we'll start with this one.
Let's see, we have the first, Carlos, before we go into the question and answer session, do you want to say a few words before we do that? I know we— No,
go ahead. Let's go jump into the questions and answers.
Say again?
Go ahead and jump into the questions and answers.
All righty. So first question that we've received is, has there been information on any benefits for employees that have insurance but have had a decrease in hours and will not have made enough to cover their premium if they are temporarily furloughed? That's a very, very good question. Currently, right now, the standard rules apply when it comes to something like this. If what you could do under the existing rules from the DOL is an employer could pay and require the employee to pay them back in the future. Or the employer could also deduct from future paychecks. So those laws have not changed. The important thing also to do here is to speak to your respective carrier on the respective insurance benefit to see if they're assisting in any way or being flexible in any way. But in terms of this act focuses on the expanded FMLA, it focuses on unemployment insurance, it focuses on paid sick leave. But your ordinary day-to-day relationships under the DOL guidance, which is already out there when it comes to benefits and whether or not you can pay on behalf of the employee or deduct from their paychecks, which is permitted from future paychecks, still remain in effect. We're not aware of any alteration to those existing laws. All right. Next. Okay, go down.
Yeah, the slides will be available. We did get that question a couple times.
Yeah, they'll definitely be available.
We will adjust them just to make sure that the typo was corrected before we send them out. So there may be a slight delay. If there is an employee who does not feel safe coming into the office because they have an elderly parent at home, what do we have to pay them by law as of today? So very good question. Question back to the person who sent this in. Will they be working at all? Is there an opportunity for this person who is not able to come into the office or is afraid to come into the office, able to do any sort of telework or any kind of work from home arrangement? That would obviously be preferable so that business operations are not interrupted by this individual able to work from home. So that would be question one. Part two of that, and this was part of our Q&A from the earlier presentation. At this point, we don't think legally that there is a basis for an employee to claim that they are too afraid to come into the office. So, to answer your question from a purely legal perspective, if they are claiming fear as a basis for not coming in, if they are also then unable to work because there is not the ability for them to work from home, so they are not working, then under the FLSA, you don't need to pay them unless, of course, they've worked part of a week and they're a salaried exempt employee, then you'd have to address that. I would say speak to your Regis HR representative to talk through those specific issues. Because these get so fact intensive, I would suggest speaking to your Regis HR representative anyway, just to make sure there are no other issues that we're missing there. But there's nothing that's changed in the law in terms of this making this being a situation where fear is one of those. A reasonable fear of coming into the workplace is an allowable reason for an employee to stay home.
Yeah, I would add on to that, and I agree with Kelly, that right now, the laws that are on the books still apply unless they're being changed. And the main act that's being changed, of course, is this COVID-19 act that we're going through as we speak. So you may be a business in Miami that is open and you're not being prohibited by the recent Miami-Dade Commission or Miami-Dade County ordinance. So you can have a policy in place that allows that requires employees to be at work, unless, of course, you fall within one of those parameters involving COVID-19 and diagnosis, et cetera. But if it's just a mere fear, you can actually require them to be there. There's no prohibition from doing that if you can stay open. What is happening out there and what we're starting to hear, and albeit it might be a weak argument, but what we're starting to hear in the legal community is that the plaintiff's bar is trying to find a way to go after businesses for some type of act of retaliation. So let's say you have a policy in place and you say, nope, we require you to work. We're allowed to do business as a result of being an exception under the Miami-Dade County ordinance. You have to be at the office, except if there's school closures. Let's say you have a telecommuting policy like that, that's limited to that. Only those with school closures can stay home and work from home remotely, and those have to appear at the office. If they violate, and it's a company policy right now because we're not required to have everybody go home unless you're prohibited from conducting business. They keep going, they violate your policy, and ultimately you terminate. Well, technically, terminating them is because of a violation of company policy. What the concern out there is with taking adverse action is that there is some form of retaliation as a result of the existing health conditions that are out there, and they're trying to piggyback on this worldwide crisis to say that companies should not be terminating employees in those circumstances when they violate these technical policies. Now, that may be a weak argument because technically under the law, you all still can follow your company policies, open for business if you're permitted to be open for business, and have a telecommuting policy that is non-discriminatory. And if the employee violates that, you can continue to go under your disciplinary practices as a business and take action. But we want to point out there is that risk. There is that risk that in this situation, you'll start seeing more and more complaints from the plaintiff's bar that companies are taking certain actions in light of these extraordinary circumstances that are somewhat retaliatory and so forth. One instance also will be termination prior to this act is another issue that has come up. I know that some of you are concerned, and this is an important issue to talk about, and I'll just throw it out there for discussion. And that is, well, this is segueing into this. This starts on April 2nd, right? By April 2nd. Well, can I just go ahead and do a termination of a big group of employees? Or can I terminate an employee because I don't want to be subject to the expanded FMLA and I don't want to be subject to the paid sick leave? Well, there is chatter, and there's recent chatter that's saying technically you may be permitted to terminate because it's an at-will employment, assuming there's no employment agreement that prohibits you from doing that. You technically may be permitted to terminate, but because of the notice that you've received and the pending FMLA, expanded FMLA, that is FMLA retaliation. And our colleagues in discussions that we're having in various organizations that we are part of are saying, yep, that might be a weak argument. It may be stronger to some and weaker to others, but yet it's what we're seeing coming down the pipe. So businesses, of course, will take legitimate business action. And that is if they have to downsize and they can't survive, and these are extraordinary times, it is what it is, even though there's an April 2nd implementation coming up. The reason that we're just throwing it out there is that's the chatter we're hearing amongst the legal community, is as we get closer to that deadline, is that considered FMLA retaliation? So I think when you govern yourself, you do have these rights under the law with at-will employment. You do have the existing ability to follow existing company policy. What the government and what others out there are not taking into account is where is that plaintiff's bar going to go from this expanded FMLA, this looming FMLA expansion and paid sick leave, and how can they create claims against employers? So I think that's in its infancy, but it's something just to keep in mind. From a technical standpoint, you have your company policies and you have your rights, but I do think it's important to keep this all front and center as we go through these uncharted waters. Okay. What happens if you are ordered to close your business via county emergency order? Do these rules still fall into place?
Yeah, so the answer is yes, they still fall into place. And one of the things that we haven't talked about, but probably should, is that everything we just discussed is phase one, right? So the law that was just signed, or the bill that was just signed into law on Wednesday night by the president, was really meant to stop the spread of this infection and keep sick people out of the office so that the virus does not spread, and what you've been hearing is flatten the curve. What is coming next is additional legislation that will help or try to help businesses in their economic recovery, and will address further questions like yours and how that, we were told by the government or our local official that we can't operate. So, are we going to have additional tax credits that are going to help us because we just had to pay for paid leave and we weren't even able to operate at all? So I would say, as of right now, the answer to your specific question is yes, but also stay tuned because there's additional legislation that's going to be coming.
Yeah. Okay.
Is
the employer eligible for the tax credit if less than 25 employees?
Yes.
The answer is yes to that.
Yes, anybody up to 500 employees.
Right. Can you go back to the first 3 slides of expanded FMLA to re-review the bullets, because I think I missed a few points? Sure.
Well,
so
we'll be sending this presentation out, so you'll be able to get the entire presentation. And certainly you can reach out to, we've got a lot of questions, so you can reach out to your Regis HR rep and they can go over it with you.
Yeah, but Carlos, I don't know if you want to chime in here. I know it's going to take a little bit, but would you prefer that we go through those slides now again?
Which slides? I'm sorry, I was trying to read an email. I'm sorry. Go ahead.
Back to the first 3 slides of expanded FMLA to re-review the bullets. I'm comfortable doing it as long as you all have time to do it.
Yeah, I think this is important. So I mean, people can always drop off the call if they're not interested. But yeah, let's do as much as we can. I think there's a lot of questions. We want to try to answer them all.
No problem. Let's go back to expanded FMLA. Yep. Can you still see the the presentation?
Yes.
Okay, great. All righty. So just to re-review, expanded FMLA. It still applies to public employers and private sector employers with fewer than 500 employees. Same thing as the House Act. It's been on the employee has to have been on payroll for 30 calendar days. This does not apply if you just hired somebody within the last 30 days. Let's say within the last 29 days you hired somebody, this is out. Well, from the date of the effective date, April 2nd, that's when it becomes effective. Limited qualifying need, it's limited. Now it's only the expanded FMLA, which as we spoke about earlier, is meant to preserve the job with the exception that we're going to speak about again in a second, but it's meant to preserve that specific position, and it's usually unpaid. In this case, it's paid, and we'll get into the part of it is paid, and we'll get into that now, but this expanded FMLA only applies in the school closure scenario, circumstances where an employee is unable to work or telework due to a need to care for a minor child if the child's school or child care provider has been closed or unavailable due to a public health emergency. First 10 days are unpaid, and the employee can take the accrued PTO or sick leave, but the employer cannot require the employee to take accrued paid leave. Now, after the first 10 days, the remaining 10 weeks, what do you pay? It's 2/3 of the employee's regular rate for the number of hours the employee would otherwise be scheduled to work. But there is a cap. Per employee, you don't have to pay more than $200 per day, and during the entire period of time, it doesn't have to be more than $10,000 total. Okay, so job protection. The employee must be restored to the prior position or equivalent, but there is an exception. For employers with fewer than 25 employees, if the position no longer exists due to operational changes caused by public health emergency, that will impact a lot of small businesses. And clearly what the government is trying to do here is assist private businesses, small businesses, get through these trying times. Ordinarily, the FMLA would have said, no, you can't. You got to give them back that position. And what the Senate and the president said is, no, not if there's operational changes caused by a public health emergency. Those companies are not required to preserve that position. Still have to pay though, but will not preserve the position. Excluded from the expanded FMLA are healthcare providers, emergency responders, and there are some exemptions. Small businesses with fewer than 50 may be exempt if providing required leave would jeopardize the viability of the business. Now, this is something that was existing in the House bill, but there's still no current guidance on this, there's not an express exemption and no automatic exclusion. So at this point, we are expecting, and I suspect Secretary Mnuchin is going to work very closely with this, that they're going to be coming out with some more guidance as to how they're going to determine who gets exempt and so forth. Okay, that answers that. So we can go back now to the question and answer session and question and answer chat room. Okay, so for sick time accrual in New Jersey, does the employer have the option to either front load the 40 hours or accrue based on 1 hour per 30 hours worked? Well, we have been looking into that issue as we've started this thing, and there's no real guidance out there. However, what we do know is that this federal right is a federal right, and it doesn't alter the state's laws on accrual. And this is an additional right provided to the employee and imposed upon the employer.
And there's no accrual in the federal law. You have the full time. Right.
So if you go back to one of the slides, it's what we did earlier. This is not to be replaced by any of that other accrual. You have whatever New Jersey requires you to abide by, you abide by that. This is a specific additional federal right. If the state of the business is such that furloughs or layoffs are needed for the survival of the business, can employees be furloughed or laid off while this whole crisis plays out?
Yes.
Yep.
I mean, I don't know whether you want me to leave it at that or expand on it, but yes.
Well, and we can expand on a few issues that may be related to that. Furloughs, for instance, if you furloughed, do you have to pay unemployment and so forth? We touched on that issue in the first presentation and so forth. And you're going to see a lot of states come back with specific guidance on that. We expect the state of Florida to come back specific guidance with more specificity on areas that are not fully fleshed out, such as furlough many employers are being, as Kelly had mentioned in the first presentation, are being recommended that if they do that, that they do go ahead and provide and go ahead and report for unemployment benefits, even if they're on a furlough position, even if they get rejected, which is consistent with what Kelly had stated in her first presentation.
Yes.
Okay, good. Yes, they can do some okay. Oh, Antoinette, I think this comes back to your original question. I think we answered that. If they can do telework, well, the company has the option. Let's go back to this question. This is the question where a specific employee did not feel safe coming into the office because they have an elderly parent at home. What do we have to do to pay them by laws of today? As discussed, there are only certain businesses that are closed, that must be closed in Miami-Dade County. If you're one of those businesses that are open and you have a telework policy in place, it can be a remote telework policy that you can limit it to, for instance, school closure scenarios, or you can expand it to those who have requested telework, but you apply it uniformly is the key. If they can work, if they want to, if you're going to allow them to telework because they're concerned about their situation, you want to get into a position where you avoid a disparate treatment, disparate impact argument. And what you want to do is try and apply it as uniformly as you can to avoid other employees getting upset for doing that. And then if they can work from home and a remote telework policy or telecommute policy. The issue there is having a clear, uniform placed across the board. Are you required to? Not in Miami-Dade County right now. If you're a closed business, you can't. Obviously, you're closed. If you're an open business, you can tailor the policy to meet the needs. Just make it non-discriminatory. A lot of businesses right now that are open are only using telecommuting policies for school closures. Some are saying across the board, if you prefer to work from home, you can. I think the key here is communication and being able to relay it to the employee in a uniform, non-discriminatory, legitimate manner. I hope that answers that question. All right.
All right. With the temporary furlough and possibly accessing unemployment benefits, how could health insurance remain uninterrupted during unemployment? The answer here is we don't know. And I hate to give that answer, but that's the truth in this situation, because as of right now, the way the unemployment system is set up, the answer is it wouldn't work that way. So we're waiting to see how the new $1 billion that the federal government is given to the states for these grants is going to work out, and how each state is going to fulfill the requirements that the state's requiring. That the federal government is requiring to get that money. And we suspect that in the next bill that's coming out, we'll also see additional information, and or we'll be seeing guidance come out following this last one that was just signed, showing the states additional information in terms of what they need to do to access that grant money. But as of right now, we don't know the answer to that question, because the goal here is to allow health insurance benefits to remain uninterrupted, but to allow employees to receive these unemployment benefits while being on a furlough versus being completely unemployed. So the answer is we don't know. We understand what people are trying to do, employers are trying to do, and we understand what the insurance industry is trying to do, and we understand what the federal government is trying to do, but nobody has figured out how they're going to make it work quite yet.
But I do think, for purposes of this, and I agree with Kelly, I think at this point, even though there's a lot of lack of guidance, there are a lot of resources. And this is where, one, I think a lot of major industries are also kind of waiting to see what happens. There's a lot of government assistance helping specific industries too. So there's probably a lot of talks behind the scenes with various lobbying groups and so forth. From the health insurance perspective, Regis, of course, is in contact with its health insurer, which many of you may be part of, so that the health insurers themselves may have specific requirements, such as, being employed to become a full-time employee and so on. And don't be surprised that in the coming days, there'll be more guidance from the health insurance themselves, even potentially, and the goal is, no guarantee, that they make exceptions to some of the current requirements to be maintained on health insurance. For instance, if you're on furlough, you're not working the minimum number of hours to be considered a full-time employee. I suspect that you'll be hearing more from the private insurers themselves in trying to accommodate these extraordinary times. All right. Are the expanded FMLA benefits applicable only to COVID-19 situations and not to individuals currently under FMLA for other reasons? It is solely, as we discussed earlier, it's solely related to that one circumstance of school closures related to a public emergency. The only public emergency going on right now to cause school closures is the COVID-19 situation. So the answer to that would be yes, because the public emergency that is being relied upon for the school closure is COVID-19. Everything else on FMLA remains the same. So still govern yourself as a business. If there's an issue under FMLA that you'd like to explore further under the standard FMLA, of course, Regis as the PEO is there to help. Those are ordinary day-to-day function as usual there. This expanded FMLA is as a result of this public emergency, and it only applies to the school closure scenario. Can you address salary? Next question. Can you address salaried employees with the sales decline of businesses? Is the safest way handle this temporary for furloughs, since we can't temporarily adjust their salary?
Well, you may be able to temporarily adjust their salary. It depends if they have employment agreements. You may want to revisit that. This may be one of those fact-specific inquiries that you want to talk to your Regis HR representative about. But you can, yes, you may be able to adjust their salaries. You may want to look into furloughs. You may want to look into layoffs. You have a bunch of different options here, depending on what your ultimate goals are in terms of retaining headcount are.
Yeah, and I would add to that, let's start with a couple of the safest ways. There is no safest way. I think you can, some people think that furloughing would raise a whole host of issues because you're providing the job, you're giving them an expectation that they can keep their job, but that is the expectation. I think the way you communicate with them if you do go down a furlough is very, very, very important. Whether you terminate, whether you furlough, and so forth, right now it's being done because of the coronavirus. Some of what I talked about earlier, there's chatter in the legal community and the trade organizations about being careful about terminating so quickly because of the April 2nd deadline, and is that going to cause retaliation, etc. Your defense is, I've got to furlough or I've got to terminate because of these severe circumstances. I think the manner in which you communicate that to employees is important. If you're a business that is obviously qualifies for WARN, it's important to make sure that's a mass layoff. It's important to check how many number of employees do you have as a business. Do you have 100 or more under the definition of employer there? Seek counsel advice on how to get through the proper WARN notices and whether or not it applies. Speak to Regis as a result of that. If you're going to go do either a furlough or a mass termination, I think it's important to see if WARN applies. Also, your employment agreements. The employments are important. You mentioned here that you may not be able to temporarily adjust their salary. That might be because they have employment agreements. If they have employment agreements, make sure that you negotiate them. If it says an amendment has to be in writing, get the approval of the employee and amend the agreement. And check what your termination rights are under the employment agreement with counsel. Can you, let's say they're at will, can you temporarily adjust their salary? As Kelly stated, you can. However, be careful in the manner in which you do that. You want to comply with applicable law. It should not be retroactive. It should be forward-looking, and it should also be done in a manner that is uniform and doesn't rise to a level of disparate treatment or impact and cause a Title VII problem. So you can still operate. It's an at-will state. Check your employment agreements. You can still operate under the existing laws, but make sure you do it in a uniform way, keeping in mind all of these overarching issues as to whether or not you have notice disclosure requirements and the upcoming expanded FMLA and paid sick leave and the potential exposure associated with that. But the answer is companies can still have a defense that their actions are done in a legitimate business manner as long as they comply with applicable laws. Okay, next question.
Regarding taking care of a child, there are a couple working for the same organization and they have a son. Both request care of a child. Legally speaking, can I deny the request to one of them? I haven't seen anything in the regulations with respect to this specific issue. Just speaking from how the FMLA addresses this issue generally, I don't think there's anything that would allow you to deny it. Like I said, I haven't seen anything that addresses it specifically. They may want to separate it though, and they may want to take it one after the other, just speaking from a practical
That's
sense.
a great point.
You know, just they may want to have one take it after the other, because we don't know how long this thing is going to last, as opposed to both taking it at the same time.
Right. In fact, that may happen. Now, I echo Kelly's comments here. I don't think that any of it, they're not distinguishing between employees, and they're not, we'll use the word quote unquote, discriminating against spouses. It's an employee right. So I agree that there is no, the way that we would recommend you do this is you look at them individually, and if they fall under, in their own respect, that right, without a explicit provision in this act that says that you can't have it, you can't be both home even though you work for the both organizations, because one of you can take care of the child. I don't think the employer wants to get in there and start making opinions and judgment as to whether or not both are required to take care of the child or not. Because it may be a situation where they both need to be home to take care of the children, even though they work for the same organization. But I agree with Kelly. I think what you'll probably see is one of them may stay home, one of them may work, just because they get the expanded FMLA, you know, for 6 months as opposed to 3 months. But I think in the end, there is no specific guidance that we're aware of at all that would prohibit one if there's a spouse already home. I think you should treat them in their own right, for, you know, at least for now, unless there's specific more guidance that comes out later. Okay, if an employee who works for a business that is still open but attempts to manipulate their schedule so as they can be off because they are afraid of work, what can be done about that? That's a good question. It kind of piggybacks on a prior question a little bit here. I think what you want to make sure is that you when it comes to scheduling outside of paid sick leave, outside of the expanded FMLA, you're going to default back to the DOL FLSA. You're going to default back to your company policies in how you deal with your employees. If you think that they're lying to you, they're not being truthful about their schedules, they're not working, they're going around they're using the process to circumvent having to go to work, and they're not being upfront, you technically have some discipline, could have some disciplinary company policies already in place to take action. The issue there, as we spoke about earlier, is a little bit of that you're starting to hear the chatter about the plaintiffs bar trying to say you're being overly retaliatory as a result of this worldwide crisis. There's a defense to that. You can operate. My business is not closed. I can expect you to follow company policies. And if you don't follow company policies, I should be able to respond accordingly. Truthfulness in the workplace is important. Document, document, document. If an issue like that comes up, call Regis. It's important to document those situations in your files that somebody is violating a company policy. Okay. If the state of the business is such that furloughs or layoffs are needed for the survival of the business, can employees be furloughed or laid off while this whole crisis plays out?
Yep.
I think we answered that already.
We answered that one.
Okay. Could we cover those?
We've covered those.
Okay. How can we validate an employee's claim of caring for a family member affected by the virus? Wait, up here, Eric.
Sorry, how can we validate an employee's claim of caring for a family member affected by the virus? In terms of the paid sick leave.
Yeah, we're assuming that this is in connection with the paid sick leave, because the expanded FMLA no longer would apply to the specific issues, physicality of the virus itself.
Right. So I think I think you would do it the same way that the FMLA, the regular FMLA, not the expanded FMLA, would require you to provide the documentation that you would need to care for a relative. There's no guidance for that yet, but I think it's a safe way to do it in terms of getting documentation that you would need to care for the health of another person.
Yeah, and I also think that, just to be clear, this act is the details that will be coming out are going to be quite extensive, we think, and they'll probably give you more information on how doctors can validate the situation to avoid any HIPAA violations or any ADA violations and not asking questions that you shouldn't be asking. We had spoken about this a lot before, where the expectation is that there will be guidance on how to verify that you're caring for a family member who may have a specific condition, and disclosure of that condition and what you can ask, how far can you go? Obviously, if you're informed of a virus, we went through how to handle that at the office. You want to be anonymous if you want others to check themselves and so forth. If any employee has been in contact with a member without giving specific identifiable information that would take you into HIPAA violations or the ADA, and we do expect more to come down the pipe on that. And there is ways, like Kelly says, existing right now of how you would ordinarily ask for a specific condition that requires you to be out of the office. There is some basic guidance out there that's there now for non-COVID-19 scenarios. I suspect that the government will be coming down with much more in the near future. Okay.
Okay, so if we can lay off, do we have to do it before April 2nd? No. You can do it at any point based on your operational needs.
Right.
Okay.
The issue here that we spoke about earlier, that I am personally hearing at the national level when it comes to group discussion with lawyers, is that yes, you can do it, but there is some of that exposure of, because it's already out there in the public, there's a risk, however weak some might think it is, of retaliation. We're throwing it out there because that is the chatter, FMLA retaliation, that is the chatter out there. Whether it's a weak argument because you have a good defense that these are extraordinary circumstances, that from a business standpoint, you can't properly operate, good defense. But the question is will this be brewing up in the coming days? And the answer is that you'll probably be hearing more from the plaintiffs bar soon. What is the deadline for the employee to elect FMLA? December 31st.
Right. Well, this expanded FMLA is only in existence through December 31st.
Right. Right. It will conclude, this act will go away and sunset on December 31st, but there's nothing stopping you from requesting it up until that point in time.
Correct. What is the tax credit to the employer? Is it the full amount of the 2/3 salary paid to the employee? Yes.
Okay.
Yeah. So it's a 100% offset of what you're paying. Okay, we have 4 restaurants with their own payroll and EIN. Each has about 15 employees. They all have the same parent company and operate under the same brand. Do the exceptions for FMLA apply to each restaurant, or are we considered an employer with 60 employees for the purposes of these exceptions? Meaning, do you have to rehire? I'm assuming this means because you're under the 25, do you have to rehire or return your employee to the position? So again, good question. There's a serious lack of guidance as to whether you would be considered a common employer under this set of circumstances. We would need to look into it further, I think. Check back with your Regis HR manager, because this is something that we can look
further when the regs come out.
Yeah, we can look into this one further. Fortunately, we have some time.
Yeah, the other thing that's very common throughout the laws with the DOL and the FLSA, and it would not surprise us in this case, is that when you start, we're already getting issues, for instance, about WARN and things like that. The DOL has out there significantly detailed definitions about what a common employer is, what an employer is, and a lot of it's consistently in the laws across, with the DOL, deal with whether or not there is common ownership or common control, and whether or not a group of restaurants that are controlled and have the same type of owners, supervisors, integrated practices, and so forth. Those types of common ownership and common control criteria is what would not surprise us would carry the day when it comes to these, and those definitions are already well established. And I suspect that they're going to go down that same route, but there's no guarantee until the final details are fleshed out here. And there's a lot of details that will be fleshed out. But I do think that they're going to start, there's a possibility they're going to go down to, does the group of restaurants that we're dealing with here have common owners and common control, and all of those indicia that are typically determined in the totality of the circumstances, the totality of the facts. There's usually a fact by fact analysis as to the factors. And even if one doesn't completely apply, do all of them, when you're dealing with control and common ownership, do they kick in and carry the day?
How long will it take for us to receive the video for today and from the other day? Okay, I think we'll have to ask Carlos Saladrigas that question in terms of when the presentation will go out.
Yep. Does the employer take the employer's word for not being able to work from home due to kid care, or is there proof that they need to provide? Well, there's nothing wrong that we've seen out there with asking to verify that the school itself has been closed and that the child attends the school. That's not a protected privacy information or anything of that nature. In fact, they have to disclose to you that the child is in a school that has been closed. It's public information as to the school. I think what you're asking for is, can you verify that the child is in that school? And if the employer there is no prohibition for asking that information. Okay. Where are we at there?
If we are allowed to remain open and an employee wants to take advantage of the situation and not show up to work, what is the best way for us to handle that?
I think we addressed that earlier with, if you're an open company, you're not prohibited from being open, for instance, in Miami-Dade or any other jurisdiction in Florida, for instance, or out of state. If you're allowed to work, make sure your commuting policy is, if you have one in place, is proper and goes back to the same analysis of the risks involved in being over, in the plaintiff's bar coming up with some arguments. But the reality is, you are allowed to set the parameters with clarity and argue that it's a business necessity down the road as a legitimate business defense. Understanding that we're in extraordinary times, and however weak some arguments out, you may or may not think they're weak. They may be out there already brewing, but govern yourself. A lot of companies are just doing school closures. Some are doing school closures. Plus, if you can work from home, we're going to work from home, but apply it with uniformity and document the manner in which they're being truthful and you're dealing with employees, so that at least you have a record of whether or not they're following or violating company policies.
Is there an age limit defined for children when it comes to FMLA, i.e. 18 and younger or 15 and younger, et cetera? So the law defines it as minor child, which would put it at younger than age 18.
Okay, we have another question that may not pop up there, but it's sent to us directly. It says, if an employee's family member is getting tested and you requested that the employee stay home and self-quarantine for 14 days, can they still remote work, and how do I plan that in a policy for the office?
Okay, yeah, the individual can still work remotely. There's no issue with that. In terms of how you can place that in a policy for the office, that can be part of your work from home policy. That can be part of your workplace health and safety policy. There's a bunch of different places that it can be. We've seen it in the workplace health and safety policy, specifically if you're showing symptoms of the illness, that you're permitted to work from home to the extent that you can, and or we require you to work from home. It's written a bunch of different ways. We suggest that you reach out to your Regis HR representative to go through where in your employee handbook and or your policies and procedures it makes the most sense to include that provision. Yeah,
and I think you don't want to be overburdened or overbearing, and if somebody is you want to be very clear that if you can work remotely, but if you can't, we're not expecting you to work remotely. I think that's important. The manner in which you apply, the key here is the manner in which the policy reads and the manner in which it is disseminated be applied in a uniform, non-discriminatory, legitimate manner. So it'd be there are going to be people who are not sick and they're just getting tested and they can work. So it's important that it be. I think where a lot of people are going to differentiate is those employees that are home, can work remotely, and are capable of working because they may not even have the virus itself, and they're capable of working without any type of limitations, and those that can't. And what you want to, in those situations, there is going to be a level of trust. And I think if somebody's getting tested and feels horrible, you're not going to delve into those medical records. You're going to have, you're not going to violate HIPAA. You're not going to violate ADA. They're going to go to, there may be a simple affirmation. I'm getting tested. I'm feeling fine. I'm going to work remotely. Or no, they're going to volunteer to you. I've been tested and I can't work. I'm feeling horrible. And I know I'm incapable of working. But your policy should be, of course, drafted in a manner that doesn't get into details of health, is applied uniformly and non-discriminatory. You will find individuals that are getting tested that can work remotely because they just simply don't feel bad.
Okay, what portion of paid sick leave will be reimbursed to the business and how quickly? So 100% of the paid sick leave will be reimbursed to the business. How quickly remains to be seen. If it works the way that Steve Mnuchin says it's going to work, these reimbursement payments should be done quarterly. So it's going to depend on the timing of when it's paid out. When the employer pays out the sick leave versus when the reimbursement is made. So for example, if the paid sick leave happens at the beginning of the quarter, it may be that the reimbursement happens either at the end of the same quarter or at the end of the following quarter. We just don't know yet. Or if it happens if the payout to the employee happens at the end of the quarter and the reimbursement happens at the end of the following quarter, it could be an offset of one quarter. It could be an offset yet, but it is at 100%.
And I think that you're gonna this tax credit issue, you're gonna be hearing a lot from the executive branch, working in conjunction with the legislative. Steve and the president have really harped on this, so I think that you're gonna be hearing a lot more from them, more active involvement from them, not just the Congress. All right. I think we just answered the next question. That was the question we had done before this last one. Okay, okay. A couple. I don't see any more questions. I do have a couple global comments. I think an overarching thing to think about. There are likely going to be additional laws that may address a lot of these issues in the future, such as new laws on retaliation. It would not be surprising that there'd be some clarity. The last thing that the administration and Congress want is that there be confusion between the public, employers and employees, as a result of this expanded FMLA that's coming down the pipe on April 2nd. So the goal is that I do hope that they go down and try and prevent a string of claims as a result of misinterpretations that could exist as a result of this worldwide crisis with COVID-19. And don't be surprised if there's new laws on retaliation coming down the pipe. Lastly, California has already suspended its statewide WARN Act notice disclosure issues and things of that nature. And there is also chatter that the federal government may also. That has not been done. We have a client right now that is one of those very, very large clients with affiliated arrangements that, under the definition of employer, does believe that they're subject to potentially the WARN because of the common control and common ownership and so forth. And they have various different establishments, and they're sending, even though this is a natural disaster in their eyes and may be considered exempted from having to do the 60 days, the WARN does encourage you to send that notice. So get counsel on WARN, even though there may be some exemptions that people are arguing, even though it's not clear that this specific scenario is in there. Some are defaulting and sending those notices anyways, just in the abundance of caution, even if it's before the 60 days. So what I would say that if you're a large company like that and you're going through some issues, seek counsel on those types of issues. I do see we just got another question that came in, and it says it would be 100% of the 2/3 pay, right?
Yes, it's a dollar for dollar.
Right.
The credit is a dollar for dollar what the employer pays.
And remember the cap. It's on the presentation. Remember the cap that that it does at some point. It is limited and so forth. Before we turn it over to Carlos, are there any other questions? I know we've run a long time with doing question and answer, but if there's any more, you're welcome to ask them. All right, well, I want to say thank you all. I'm going to turn it over back to Carlos Saladrigas. It's been an honor working with you all on this, and we're available for future, depending on how things go and what Regis prefers to do. And I wanted to thank you. It's been an honor for the opportunity to present these issues and continue to present them. And again, I want to just reiterate thank you to Carlos Saladrigas and the entire Regis HR team. So thank you so much.
No, thank you, everybody. Thank you, Carlos and Kelly. That was great as always. Again, to all our clients, I promise you we're staying on top of this. As soon as something else comes up or anything different changes, we'll continue to do these, as soon as possible or as soon as the information comes out. Please stay in touch with your HR rep as you have been. And like I said, we're all here for you 24/7. And we're going to get through this somehow. But thank you, Carlos and Kelly, again. Thank you to my incredible HR team that has been nonstop, working a lot of hours. But thank you all, and we'll be in touch early next week, I'm sure.
Thank you all.
Everybody stay safe, please.
Yep.